Hello everyone, welcome back to Criminal Procedure. For this video, we will discuss about motion to quash under Rule 117. So the following are the principles that we are going to discuss here, the principles that you are going to remember about motion to quash. So first is, what is the nature of a motion to quash? Second, time for the filing of a motion to quash. Third, form and contents of the motion to quash. Fourth, grounds for a motion to quash. Fifth, effect of failure to assert any ground of a motion to quash. And sixth, what are the alternatives of the court when confronted with a motion to quash? So let's begin discussing the nature of a motion to quash. So under the rules, a motion to quash is the mode by which an accused assails the validity of criminal complaint or information filed against him for insufficiency on its face in point of law or for defects which are apparent in the face of the information. So I call this an attack to the extrinsic validity of the complaint or information because generally the grounds for the filing of a motion to quash are based on the face, those defects which are apparent in the face of the information. But there are also grounds for the filing of a motion to quash based on the provisions of the law on its face in point of law. Example of that is if the facts stated in the complaint or information do not constitute an offense. So the basis for that is the offense, which comes from the law, okay? And there are also defects that are apparent in the face of the information. For example, if it does not conform to the substantially to the form, as required by the rules of court, okay? So a motion to quash has the characteristics of an omnibus motion. So when you say omnibus motion, it means that if you have found any ground for or objections as to the validity of the complaint or information, or if you have found defects in the complaint or information, you should raise them in the motion to quash, all of them. Because if you fail to raise them in the motion to quash, then all the objections not so included in the motion to quash shall be deemed waived. So you can no longer raise them later on, but save the exceptions provided for under the rules of court. So when can you file a motion to quash? So under section 1 of Rule 117, a motion to quash may be filed at any time before entering a plea or before arraignment. Because if you have watched my previous video about arraignment, we discussed there that one of the remedies that the accused can avail before arraignment is the filing of a motion to quash under Rule 117. And the effect if the accused fails to file a motion to quash under Rule 117 before arraignment is that he is deemed to have waived his right to file or to raise any objections on the extrinsic validity of the complaint or information or on the intrinsic validity in the face of the information. So that is generally the effect. Again, save the exceptions provided for under the rules of court. So there are exceptions to that rule. Now, generally, a motion to quash is not allowed in cases covered by the rules on summary procedure. So this is a prohibited pleading under this particular rule. But the exceptions are if the motion to quash is grounded upon lack of jurisdiction over the subject matter. So you can properly raise that in a summary proceeding. Because even in an ordinary criminal proceeding, even if you fail to raise that ground, lack of jurisdiction, the court can still take into consideration that particular ground, even motu proprio. So, kaya exception din siya sa rules on summary procedure. And the second one is if the motion to quash is grounded upon failure to comply with the barangay conciliation proceedings. While this particular ground is not found under Rule 117, the rule says that this is a special ground under the rules on summary procedure. Because if you have filed a complaint or information without the requisite barangay conciliation proceeding, then the criminal case is premature. And therefore, there is no cause of action for you to file that criminal complaint. So you can properly move for the quashal of the complaint or information on that basis. Now, form and contents of the motion to quash. This is very important because if you fail to follow Section 2 of Rule 117, then your motion to quash may be denied by the court. The motion to quash shall be in writing, that is number 1. Second is signed by the accused or his counsel, number 2. And third is that it should distinctly specify its factual and legal grounds. So you should state the facts which will lead the court, no? Or what are the facts, no? Why did you say that this particular complaint or information has should be quashed, or what particular defects in the complaint or information that justify or that will support the quashal of the complaint or information. And of course, you will support it by legal grounds. Example of that is if the court lacks jurisdiction over the offense charge. So you will state or specify in your motion to quash that, say for example, the complaint was committed in Davao City and the court trying the case is the RTC of Tagum City. So you may move for the quashal of the information or complaint because the court has no jurisdiction over the offense charge, because in criminal proceedings, venue is jurisdictional. So if hindi yan na-commit within the territorial jurisdiction of the court, then necessarily the court has no jurisdiction over that particular offense. So therefore, yun ang way mo of specifying the factual circumstances that would support the quashal of the complaint or information. So the rule here is that kaya kailangan nating specify yung factual and legal grounds for the filing of the motion to quash is that because the court will not consider any ground other than those stated in the motion. Kasi nga sabi natin, di ba, that a motion to quash is in the nature of an omnibus motion, which means that if you have grounds or objections to the complaint or information, raise them in the motion to quash, all of them. Because if you fail to raise them in the motion to quash, then these objections are deemed to have been waived. So, consistent with that rule, then the court will not consider any ground that is not stated in the motion to quash. But again, we have an exception to the rule, which is lack of jurisdiction over the offense charge. Because again, this can be taken into the consideration with the court motu proprio. So, a motion to quash, if it is granted by the court, pwedeng ma-dismiss yung case. Pwedeng ma-quash yung complaint or information, ma-dismiss yung case. But this is not the same with demurrer to evidence. Although, meron silang parehas na purpose, kaya lang magkaiba sila ng ground and magkaiba sila ng rule. So, ano nga pala ang distinctions between the motion to quash and a demurrer to evidence? So first is that yung motion to quash, sabi natin, it should be filed before the accused enters a plea. Otherwise, he will lose the right to file a motion to quash. But then again, save those exceptions provided for under the rules of court. Ulit-ulit natin sinasabi yun kasi may mga exceptions to the rule. On the other hand, a demurrer to evidence can only be filed after the prosecution rests its case. So kapag nag-file ka ng demurrer to evidence, before natapos si prosecutor mag-present ng evidence, the demurrer to evidence will be premature. It can be dismissed. Kasi, malalaman natin later no, kung bakit ganun. Bakit after the prosecution rests its case. Okay? Second is, a motion to quash does not require a prior leave of court. So you can just immediately file a motion to quash no, without asking a permission from the court. And it will not affect your case no, if, for example, the court will deny your motion to quash. But in demurrer to evidence, merong effect, may kaibahan kapag nag-file ka ng leave of court at kapag hindi ka nag-file ng leave of court. So, kapag nag-file ka ng leave of court, ang mangyayari is that if the demurrer to evidence will be denied by the court, then the accused will be given the opportunity to present evidence. So, magko-continue lang yung trial. But if you failed to file a leave of court no, before filing a demurrer to evidence, then ang effect nun is the accused will lose the right to present his evidence. And therefore, the case will be submitted for decision na siya based on the evidence of the prosecution. Yun ang kaibahan sa demurrer to evidence. In motion to quash, the grounds are generally based on matters found on the face of the complaint or information. So tinitingnan dito sa motion to quash yung laman ng complaint or information. For example nito is if the facts of the complaint or information do not constitute an offense. So meaning to say, you will look at the allegations, the material allegations on the elements. Kung sufficiently nakalagay ba doon yung lahat ng elements of the offense. Kasi kapag wala, then you can move for the quashal of the complaint or information because the facts alleged therein do not constitute an offense. Ano pa? Say for example, the complaint or information do not conform substantially to the form, to the prescribed form. So remember, meron tayong mga rules, no? Rules kung kailan nagiging sufficient yung complaint or information for the filing of a criminal complaint. 'Di ba? So kailangan lahat ng rules na 'yon makikita mo doon sa complaint or information. If wala yun sila, then you can move for the quashal of the complaint or information. So basically, yung grounds ng motion to quash can be found on the face of the complaint or information. Another example is if the complaint or information charges 2 or more offenses. Di ba bawal yung mga duplicitous offenses? Kasi kailangan yung complaint must contain only 1 offense. Di ba? Unless na lang if the act complained of results to 2 or more offenses. Yung tinatawag natin na complex crime or compound crime. Okay? So yun siya. But in the demurrer to evidence, here, the ground is based solely on insufficiency of evidence. More on intrinsic tayo, hindi sa face ng complaint or information. Dito, pinag-uusapan natin kung yung evidence ba ng prosecution will prove the guilt of the accused. So yan na yung weight na, yung weight na ng evidence, yung pinag-uusapan dito kung mabigat ba or sapat ba yung ebidensya laban sa accused. So yan yung ground natin in demurrer to evidence. This explains why a demurrer to evidence can be filed only after the prosecution rests its case. Kasi nga, you will look into the evidence of the prosecution. So kapag hindi pa tapos si prosecutor mag-present ng evidence, then it will be premature for you to file a demurrer to evidence. Kasi tinitingnan natin after the presentation kung ang lahat ba ng ebidensya ng prosecution ay sufficient para i-prove yung guilt ni accused. So yan yung reason kung bakit a demurrer to evidence is filed after the prosecution rests its case. Lastly, a motion to quash when granted, a dismissal will not necessarily follow. So hindi ibig sabihin na kapag si court, ginrant niya yung motion to quash mo, hindi ibig sabihin na madidismiss automatically yung case mo. The court has alternatives. He may or it may order the amendment of the complaint or information para i-correct yung mga defect doon, or it may order the prosecution to make another information or complaint. So, hindi siya automatic na madidismiss yung complaint. But in the mirror to evidence, when granted, a dismissal will necessarily follow. And take note here that if the case is dismissed on the mirror to evidence, is that the effect is that it has the effect of an acquittal. And therefore, kapag acquittal siya, the prosecution cannot file an appeal on the judgment of acquittal kasi it will constitute violation of the right of the accused against double jeopardy. But here in motion to quash, kahit na ma-dismiss yung complaint, it doesn't mean that another complaint or information cannot be refiled. So pwede pa rin, no? Wala siyang effect of acquittal yung motion to quash. Except na lang if the ground is double jeopardy or if extinguish na yung obligation or criminal liability. So, hindi na pwedeng ma-refile yung case. Pero kung, let's say for example, lack of jurisdiction lang over the offense charge, then the prosecutor may file it in the court which has jurisdiction over the case. So, it doesn't mean na na-dismiss yung case based on a motion to quash, hindi na pwedeng i-refile yung case. But in the mirror to evidence, this has the effect of an acquittal, and therefore, there should be no refiling of the case, no appeal, because that would constitute a violation of the accused against violation of his right against double jeopardy. So let's move on to the next slide. So what are the grounds for the filing of a motion to quash? So under Section 3, the accused may move to quash the complaint or information on any of the following grounds. Number 1, that the facts charged do not constitute an offense, that the court trying the case has no jurisdiction over the offense charge, that the court trying the case has no jurisdiction over the person of the accused, that the officer who filed the information had no authority to do so, that it does not conform substantially to the prescribed form, that more than one offense is charged except when a single punishment for various offenses is prescribed by law, that the criminal action or liability has been extinguished, that it contains averments which, if true, would constitute a legal excuse or justification, and that the accused has been previously convicted or acquitted of the offense charge, or the case against him was dismissed or otherwise terminated without his express consent. So let's start with that the facts charged do not constitute an offense. So here, you'll just examine the complaint or information. So you look at the elements. If lacking yung elements, then you can file a motion to quash based on this ground, that the facts there alleged do not constitute an offense. Second is that the court trying the case has no jurisdiction over the offense charge. So here, you will not only take note of the jurisdiction of the court over the subject matter, because in criminal proceeding, venue is also jurisdictional. So aside from the subject matter, the offense itself, you look at the venue. Saan ba na-commit yung crime? Then you will know if the court has the jurisdiction over the offense charge, because venue in criminal cases is jurisdictional. Third, that the court trying the case has no jurisdiction over the person of the accused. So, ito yung, if you will, assail the legality of the arrest, the warrant of the warrantless arrest, or the validity of the warrant issued, then ang way mo of raising that is through a motion to quash, because the court has no jurisdiction over the person of the accused. Letter D, that the officer who filed the information had no authority to do so. So, for example, if the information was filed by an associate prosecutor, for example. So, kung wala siyang authority na siya yung magpirma ng information complaint, so dapat yung talagang head of the prosecution office. So kung ganyan, pwedeng under this ground, you can file a motion to quash. That it does not conform substantially to the prescribed form. So you should look back, or you should recall what are the rules for the sufficiency of the complaint or information. Okay, you should recall the rules on the sufficiency of the complaint or information. So if you can still remember what are the rules. So number one is that, diba, you should state the name of the accused, the address, and if his name is not known or his full name is not known, then you may write his nickname in the complaint or information, or any affiliation to which he is known. So if hindi mo naman siya kilala talaga, pati yung full name tsaka yung nickname niya, then you may write John Doe or Jane Doe. So fictitious name, okay? And later on, kapag nalaman kung ano talaga yung name niya, then it will be inserted to the complaint or information. Aside from that, name then, same rule, no, with respect to the name of the offended party. And then you should state, no, the acts or omissions complained of, no, constituting the offense charge, and that the designation of the offense given by the statute, di ba? Kailangan mo ilagay yun. Pati yung mga aggravating circumstances of the offense. So, ito yung mga matters that you should state in your complaint or information so as to substantially conform, no, with the form, prescribed form for the filing of the complaint or information. So, kapag hindi yun nasunod, example, kapag kulang yung mga information doon, yung form niya, aside from that is that, di ba, para makafile ka ng complaint, kailangan subscribe ito ng offended party. Kung hindi yan subscribe, then that could also be a ground for the quashal of the complaint because it does not conform substantially to the prescribed form. Letter F, that more than one offense is charged except when a single punishment for various offenses is prescribed by law. So this is what we call as duplicitous complaint or information. So take note of the general rule. A complaint or information must charge only one offense. So this general rule prohibits duplicity of offenses in a single complaint or information. So if that is the case, then you can file a motion to quash. But an exception to this rule is that if the single act violates two or more entirely distinct and unrelated provisions of law, the prosecution of the accused for more than one offense in separate is justified. Ito pala is kapag distinct yung yung na-violate na law, so pwedeng separate information. Gaya ng, for example, no, yung sa drugs case, although same sila na Republic Act 9165, kapag different na section, separate information yan siya. Hindi yan siya allowed na ilagay sa isang information or complaint kasi that would constitute a duplicitous complaint or information. Pero kapag yung single act will result into two or more offenses, ang example nito is reckless imprudence resulting to homicide and serious physical injury. Kasi yung single act na yan, nakapatay siya ng tao at saka naka-injure siya ng tao. So that would be allowed in one complaint or information. So a complaint or information may contain two or more offenses when the law prescribes a single punishment for various offenses, as in complex and compound crimes treated under Article 48 of the revised Penal Code. So remember that principle. What else? That the criminal action or liability has been extinguished. So here, you remember or you recall the rules no, on prescription of actions. Okay? Kasi kapag na-prescribe na yung criminal action, then that you can move no, for the quashal of the complaint or information. That it contains averments which, if true, would constitute a legal excuse or justification. So, if the complaint or information has justifying circumstances, no? And lastly, that the accused has been previously convicted or acquitted of the offense charge, or the case against him was dismissed or otherwise terminated without his express consent. So this is double jeopardy. So double jeopardy is quite lengthy. So I will have a separate video for double jeopardy, no? Para ma-discuss natin kung ano yung mga elements of double jeopardy. But for this video, we will just proceed no, to the next slides. So what is the effect of failure to assert any ground? Ito na-mention na natin to kanina. Because a motion to quash is an omnibus motion, the failure to assert any ground of a motion to quash before a plea to complaint or information shall be deemed a waiver of any objections. So it's either the accused did not file a motion to quash or the accused filed a motion to quash but failed to allege the ground in the said motion. Kasi nga sabi natin, ang characteristic ng motion to quash is that it is an omnibus motion. So if you have objections then available at the time, then you should raise them in the motion to quash. But eto na, dumating na tayo sa exceptions. The exceptions are as follows, no? One, that the facts charged do not constitute an offense. So even if you have not raised this particular ground, you can still assert this ground no, after arraignment. Second is that the court trying the case has no jurisdiction over the offense charge because the court may, no, motu proprio, consider this ground no, kapag wala siyang jurisdiction over the case. Kasi ang effect niyan, kapag nag-take cognizance siya ng case na wala naman siyang jurisdiction, magiging void din naman yung judgment niya, di ba, on that case. Third, that the criminal action or liability has been extinguished. And lastly, on the ground of double jeopardy. So the reason here is obvious, di ba? Bakit mo i-allow na kung convicted na pala siya or na-dismiss na pala yung complaint niya on the same offense, the same act, the same person, the same lahat, bakit mo pa siya kailangang i-charge ng same na offense? Same instance, same nangyari, di ba? So that would be prejudicial to the interest of the accused. Tapos na, dati, bakit ngayon? Meron na naman, di ba? So that is double jeopardy. Yan yung basically the reason why a criminal case should be dismissed, no? Or quashed on the ground of double jeopardy even after arraignment. And ito ding extinguish na yung criminal action, useless na din, no? Para mag-proceed to trial. Kasi wala naman talagang criminal liability na in the first place kasi nga extinguished na siya. So what are the alternatives of the court when confronted with a motion to quash? So number one is if the motion to quash is meritorious, then the court may order the amendment of the information or sustain the motion, but the court can still allow the prosecution to file another information. Ito yung sinasabi natin kanina na hindi ibig sabihin na kapag nag-grant yung motion to quash mo, automatically the case will be dismissed. Kasi the grant of the motion to quash will not bar the filing of another information. Except na lang kapag yung ground ng motion to quash is based on either the extinction of the criminal liability or because of double jeopardy. Again, the reason is obvious. it would be useless for the court to continue with the case since the criminal liability no longer exists. Hindi na siya, wala nang cause of action to file that criminal proceeding. Second is that if the motion lacks merit, kapag wala namang silbi yung motion, the court may deny the motion. Bakit may yung nilagay natin dito? Kasi baka may mga ground dyan na pwedeng i-take cognizance ng court, gaya ng lack of jurisdiction over the offense charge. Kasi pwede naman motu proprio. So, kahit na walang merit yung motion, yung mga facts and legal grounds that are alleged in that motion, pwede namang mag-consider si court ng mga grounds na pwede niya i-consider kahit na hindi nakalagay doon sa motion to quash. So kaya may ang nakalagay dito kasi discretionary sa court yan. And take note that the denial is interlocutory in nature and therefore you cannot appeal the order of denial of the motion to quash. That is not allowed. Kasi hindi naman yan final judgment or order. Isa lang yung interlocutory order. The denial of the motion means that the criminal case should proceed to trial. So hindi ibig sabihin na kapag na-deny yung motion to quash mo, the accused will lose the right to present evidence. Ang mangyayari is that mapoproceed lang to the normal or to the regular criminal proceeding. So mag-start siya from the prosecution presenting its evidence to the accused presenting its evidence. And then it will be submitted for decision after. If the denial is tainted with grave abuse of discretion amounting to lack or excess of jurisdiction, then the remedy is Rule 65 by petition for certiorari. So ito siya, di ba sabi natin, since yung motion to quash or yung order denying the motion to quash is an interlocutory order, bawal yung appeal. Pero kapag tainted yan with grave abuse of discretion amounting to lack or excess of jurisdiction, then you can file a petition for certiorari under Rule 65. Okay, so that ends our discussion for Rule 117, motion to quash. So if you have any questions, feel free to comment down below and we will give time to answer your questions. See you next video and goodbye.